pleasantly warm days in Ottawa, spring days. It's a nice change from the winter we left behind in Calgary. To discuss with you a developing area of the law, cannabis in the workplace. This year marks the 35th anniversary of the signing of the Charter of Rights and Freedoms. That was signed on April 17th, 1982, making it part of Canada's supreme law, its constitution. Section 7 of the Charter guarantees the right to life, liberty, and security of the person. And it is that section of the Charter that the Ontario Court of Appeal used to invalidate the criminal prohibition of the possession of cannabis in a decision, R.V. Parker, issued on July 31st, 2000. Parker held that the prohibition of the criminal prohibition of possession of cannabis was unconstitutional, as it did not contain an exemption for medical users.
Actually, I think it's a good idea to take a look at the basic facts of the Parker decision, because I think context is important here. Just to put a human face on the case here, Parker was an epileptic who used cannabis to treat his epilepsy. He suffered from severe and frequent and life-threatening seizures. He found that traditional medicine did not work for him as much as marijuana did. He found that cannabis did in fact help his traditional medicine to reduce the incidence of seizures through the smoking of that cannabis. You got to keep in mind that in these days, cannabis of all forms was illegal, completely prohibited, even for medical purposes, and except by way of a special discretionary exemption granted on a case-by-case basis by the minister directly, which, as you can imagine, did not occur all that often. So, not being able to source his own legal marijuana, he grew his own plants. Eventually, this was discovered by the police. He was charged with possession of marijuana and growing marijuana in his home. So, I noticed that Jillian, just prior to us, already went over this history, so we're going to go over it really quickly. But we'll highlight the main important points, especially as the Charter is concerned, as it applies to our presentation particularly. So,
the Ontario Court of Appeal gave the government 1 year to come up with a regulatory regime for medical access to cannabis that was satisfactory to the court's concerns regarding constitutionality of the criminal prohibition. Of course, in response to the Ontario Court of Appeal's decision in Parker, the government issued the Marijuana Medical Access Regulations, the MMAR, on July 30th, 2001, 1 year less a day, of course, from the 1 year deadline given by Parker to do so. In the 2003 case of R.V. Hitzig, the Ontario Court of Appeal dealt with a challenge to the MMAR by several medical marijuana users who challenged the MMAR as unconstitutional, in that the MMAR failed to provide adequate access to medical supply of cannabis, marijuana, forcing patients, of course, to the black market and the risks associated with black market product. As a result of the finding in Hitzig that portions of the MMAR were unconstitutional, the decision of Parker in the Court of Appeal in Parker that the criminal prohibition of possession of marijuana or cannabis was unconstitutional, as it did not have a valid medical regime, constitutional medical regime for access to cannabis. So the law of the land, as per Parker, stood. In response to the Hitzig decision, the government reissued the MMAR to address deficiencies in the MMAR identified by the court in the Hitzig decision. The new MMAR permitted the government to supply cannabis to licensed users, but did not obligate the government to do so. There was no legal obligation in this revised version of the MMAR that required the government to supply. Again, we look at another challenge to the MMAR challenged, and we have, in the meantime, we've got a back and forth between the government and the courts over the MMAR, whether or not they're valid. But in 2008, the Federal Court of Canada, in the case of R.V. Svekopoulos, dealt with another challenge to the MMAR, and I'll let John go through this.
Yeah, by now, the government's pretty much announced, before this actually, that'll produce and distribute medical cannabis itself. And that was out of an abandoned mine out in Flin Flon, Manitoba, you may recall. The MMARs were amended to allow a medical user to obtain medical cannabis from the site, from the government as the sole licensed provider of it. It turns out, though, that the Manitoba site wasn't all that good. Anecdotally, people were saying that the product wasn't good. There was a single product with a single profile available to people, and beyond that, the government's own statistics showed, perhaps more importantly, that 80% of people who needed medical cannabis couldn't get it. They couldn't grow it because of their own circumstances at home, or they were too ill, and they couldn't get it from the government source. So essentially, the court looks at this and says it's an undue restraint for the same reasons as since the 2000 decision, which is forcing medical users to the black market, with all the dangers inherent in that, and injecting money to organized crime inherent in that. And so that, in turn, was determined unconstitutional.
So after the MMAR were determined to be unconstitutional in Svekopoulos, there continued to be a volley back and forth between the government and the courts over the validity of the MMAR. In response to the continued deficiencies identified in the MMAR by the courts, the government enacted the Marijuana for Medical Purposes Regulations, the MMPR, in July of 2013. The Supreme Court of Canada in 2015 addressed the failures identified in a case R.V. Smith with the MMPR. It addressed the challenge to those regulations and identified deficiencies with them once again.
Yeah, Smith was kind of a good Samaritan type. He actually didn't use medical cannabis himself. But he assisted those through an organization back where he lived on Vancouver Island out of Victoria, and he processed the dried marijuana that was available through the regulations at the time, processed it into edibles and extracts. The problem is, of course, that the MMPR at the time only permitted possession of dried marijuana. Essentially, the court said that makes no sense. There's no reason to prohibit extracts because presumably when you ingest cannabis orally, for example, the effect is more predictable and it is more, some people it works better for them, besides which smoking is supposed to be bad for you anyway. So to prevent that, the court essentially said, again, an unreasonable restriction, go back and do it again. So they did. And that's how we get the ACMPR today.
So as it stands, since the enactment of the ACMPR, they are the law of the land until further notice. As you can see from the decisions, the Charter has played a vital role in the development of medical cannabis in Canada. But at this point, it's also important, and we're talking about cannabis in the workplace, to recognize the role of all of the provincial human rights legislation that will and does impact the medical cannabis and the workplace?
Yeah, so we've got a few, as you can see, parallel systems in Canada to deal with this. The charter is obviously hugely important, as Alex says, for human rights law, but it's not the whole picture. Criminal law is of federal scope, and that's why the charter applies to it directly. The charter is supreme law, and all laws that are passed, including the criminal code, are subject to it. Otherwise, unless we're talking with a federal employer, or a government employer rather, we're looking at provincial human rights legislation, which expands the ambit of the charter quite significantly, and in a way that's very much relevant to what we're talking about here. And finally, we've got the recreational and the medical parallel systems, which we'll touch on very briefly, which have very widely different implications for workplace usage of cannabis, as you'll soon see. Yeah. So these are the questions I hope to, or we hope to at least, answer today. Whether an employee can use cannabis recreationally or medically at work, whether they can obtain medical cannabis through an existing drug plan, that's a particularly live issue right now, and whether an employee needs to disclose cannabis prior to usage with their employer. And in the context of medical cannabis, I'll not keep you in suspense. For that last question is very likely yes. The courts do not look kindly on people that are in a potentially dangerous situation at work, for example, and hiding a potentially impairing behavior at work. So in the medical context, the recommendation, generally speaking, is to disclose that prescription and to your employer. With respect to that, you are protected under, generally speaking, the human rights legislation in each province. But we'll talk about it more in a second. So talking recreationally here, right now it's very easy because recreational cannabis is still illegal. An employer is well within their rights to impose discipline or to have an employee policy in place that prohibits recreational use of cannabis in the workplace or to be under the influence of recreational cannabis in the workplace. After legalization, though, things get a bit more complicated. But before I get into that, more background, we don't have at-will employment in Canada. As is the case in the United States, in some states, an employer cannot simply terminate you for no reason at all, without a reasonable notice period or pay in lieu of that notice period, unless you're terminated for cause. One example is theft. Simply, if the employee is frustrated that relationship sufficiently with egregious conduct, you can be terminated without that notice period. Makes sense. The question here is, does using recreational cannabis justify a for-cause dismissal? And keep in mind, even if the answer is no, an employer can still terminate. They just have to give you reasonable notice for dismissal. Again, we're talking about the recreational context here. And even if the employer decides to impose discipline or dismissal, they need to do so properly. And that's a way of saying it needs to be, an employee policy needs to be fair and it needs to be applied consistently and not arbitrarily. Discipline has to be proportional to the conduct that has been taking place, and it needs to be progressive. And progressive simply means you start out with a verbal warning, you go to a written warning, you have a performance review, and ultimately move to termination if corrective action on the part of the employee is not implemented. Again, on the other hand, if the misconduct is egregious enough, then yes, that dismissal can take place. We'll see that in a few examples very shortly, but unfortunately, there's no easy answer that applies to every circumstance. So a few questions to ask right off the hop is, what is the job? That's perhaps the most important question, because if you're in a safety-sensitive position, or if you're around children, cannabis use might not be conducive to employee activity. If we take alcohol for an example, because it is also a regulated and intoxicating substance, some jobs entail, or even expect, drinking at work. A lot of sales positions come to mind, taking clients out. I'm not saying go to work absolutely hammered, but social drinking is a thing. It's done at work functions, and it's not problematic in a lot of cases. On the other hand, a grade 3 teacher having a few shots in front of class, probably not appropriate. So, with the obvious stated, let's move on. Next question to ask is the usage sufficient to cause impairment? This is a huge question, actually, and likely one which will cause the most uncertainty and the most problems going forward because of a lack of research, and honestly, we just don't know. The bottom line is we don't really know what level of ingestion causes impairment in a lot of cases. With alcohol, it's very easy. You blow into a device, you get a number. That number tells you if you're impaired or not. It's a very linear relationship. It's very predictable. This does not apply to the cannabis context. If you combine that with a lack of easy technology, at least at present, to measure impairment, this makes it even harder. The problem rears its ugly head, I think, in the motor vehicle realm, and I expect we'll see in a lot of court cases these questions raised. But that aside, we need to do some sort of investigation, the employer and the employee in that employment context, as to whether the job in question requires freedom from impairment by cannabis. And even if not, what that level of intoxication is that has attracted that disciplinary focus. And finally, we might have a question to ask of whether cannabis use is tolerated in the workplace. Do the employees use cannabis on the lunch break, for example, with their supervisor in full knowledge? All very relevant considerations to be made. So I'll just actually go quickly over these cases because they provide some good examples of all that theory which I've just laid down. The first is Stone. In this case, we're not talking about a safety-sensitive position. His job was to calibrate fabrication machines. We have an employee that drinks on the job with full knowledge of the employer, but he's never reprimanded. We're talking several bottles of beer at lunch here. In this case, there was an employee policy in place which prohibited substance abuse, but which also said that focus should be on correcting behavior rather than punishment. Fair enough. Despite clear evidence, though, of drinking on the job and clear impairment on the job, the court ruled in this case he was unjustifiably terminated. This was not the first incident, and without prior reasonable warning that such conduct was not acceptable, they could not simply dismiss him at will. That's the ratio of that case. Very interesting. On the other hand, we've got Walker and Imperial Oil as another example, as a counterexample. And this is an example of what happens perhaps in a safety-sensitive position. Mr. Walker, in this case, had a pre-scheduled alcohol test. We have a zero tolerance policy here. The worst case scenario is a large explosion, killing people. So Mr. Walker gets hammered anyway and shows up late, fails the test, is fired. He contests that in the court, of course. says no, that's wrongful. That's not wrongful dismissal. He was justifiably terminated. The question is why? What are the differences between these two cases? And the obvious answer is, well, that safety-sensitive nature of that job. It would appear that recreational impairment, this is why we talk about alcohol, because it's recreational impairment. In a safety-sensitive position, that can result in termination. In this case, the danger involved justifies that zero tolerance policy. The other difference is the employer application of that policy. It was not arbitrary, it was done consistently in the Imperial Oil decision. They did not ignore it in some cases and apply it in others. It's really the same, different sides of the same coin though, in that the conduct was sufficient to warrant a for-cause dismissal in that case. And in every case, the court will balance that. So, as I said before, the main difference between alcohol and cannabis is whether impairment is provable. And again, in these cases, impairment is obvious. It may not be so in the cannabis context. So if I may, the bottom line here is if we can show that cannabis impairs your ability to function, and if you're in a position which sufficiently justifies that zero tolerance policy for impairment, then yes, you can be fired. That's the answer. If you cannot at least be fired, you can still be disciplined. If that's what the employee policy calls for. So, at least my recommendation at this point is even post-legalization, if your employer requires you to be free from the influence of cannabis at work, you might probably be disciplined for doing so. But let's take it out of the recreational realm here and talk about medical use. So can an employee take medical marijuana at work? And yes is the general answer here, but there is a lot of nuance to this question. And this is actually where the human rights legislation clearly and really comes into play. Human rights legislation prohibits discrimination in every province due to disability. One obtains medical marijuana because of a disability with a prescription. And therefore, to discipline an employee over their use of medical cannabis is discriminatory. And an employer has a duty to accommodate that employee within reason. As usual though, some exceptions may apply. For instance, if you are in a safety-sensitive position and you're sufficiently impaired by the use of your medical cannabis such that you cannot do your job, there will be an issue. If you demand the ability to smoke medicine when orally works just fine, and the work environment does not lend itself to smoking, that can cause a problem. The employer might reasonably reassign you to a different position if safety is an issue, where your medication will not interfere with that work. If it is what they call in the courts a bona fide occupational requirement, all that means is you need to be clear of mind to do your job. If it is that bona fide occupational requirement to be free from the influence of cannabis, the employer must accommodate. If the employer cannot accommodate without incurring undue hardship, they can legally discriminate. So we'll give a couple of examples in the case law. The first one is Entro and Imperial Oil. In 1989, there was an event called the Exxon Valdez oil spill. As a consequence of that, the spill had many causes, perhaps the most famous of which was a drunk captain sleeping below decks. He left an overworked third mate in charge. He was trying to avoid icebergs, ran aground, and we have the worst environmental disaster in 1989, at least up until Deepwater Horizon. But as a result of that spill, at least most of the oil and gas industry across North America introduced new policies to screen for drug and alcohol use and impairment. At least insofar as safety-sensitive positions were concerned. Mr. Entro, in this case, was in such a safety-sensitive position. The alcohol and drug policy at Imperial said that prior substance abuse problems had to be disclosed and that the employee would be reassigned while they attended a mandatory rehab and abstinence period. The random testing was implemented, a positive alcohol or drug test, including drug metabolites, interestingly enough, would result in an immediate zero-tolerance dismissal. Mr. Entro did so disclose a prior abuse problem in this case. 5 years before being hired, he was an alcoholic. And he was reassigned upon being hired and upon disclosure of that to a non-safety sensitive position. And he complained about this to the Human Rights Tribunal. Is this discrimination on the basis of disability or the perceived disability of Mr. Entro? This is where it gets a little bit more relevant to cannabis, though, is because the court ultimately held in this case that those elements of the test could show an actual and on-the-job impairment were justified. And that zero-tolerance policy was justified in that case. But those elements of the test which could not show actual on-the-job impairment could not be justified, which shows, which could example be shown by those drug metabolites from marijuana consumption a few days ago. Dismissal in that case wouldn't make a lot of sense from the court's point of view because you're not technically impaired on your job. Let's contrast that with another example. In Kellogg, the employee is in a safety-sensitive position. He smokes cannabis prior to a scheduled drug test. There's no evidence that it was used to treat a drug condition or a medical condition, or it was an addiction. The court accepted evidence that cannabis use, even on his own time, and even days beforehand, did actually cause an impairing effect with his job abilities. And therefore, in this case, the policy of drug and alcohol testing was actually found to be totally fine. And we move on to the City of Calgary. We've got a heavy machine operator in this case, so another safety-sensitive position. He's injured at work. He gets a prescription for the use of cannabis for his payment. And he informs his employer about this use. And they reassign him, pending an investigation as to whether the cannabis use would be impairing to his safety-sensitive position. Ultimately, no evidence was able to be obtained by the City of Calgary, his employer, that the use was impairing. As such, the medical cannabis user in this case was ordered reinstated into that safety-sensitive job. The bottom line is impairment by cannabis, medical cannabis, or even recreational cannabis, is a case-by-case basis, case-by-case thing every time. And the employer and the employee need to work together on that disclosure to determine, medically speaking, if they are free from impairment in the course of those duties. So let me just talk about unions really quickly because there's some additional considerations that apply. The use of cannabis in this case will be considered in the context of the union contract, which basically just means that the courts will not allow the employer to, outside the scope of the union contract, unilaterally impose alcohol or drug screening. The union actually has to agree to it. That's the general rule. There are exceptions. There has been shown to be a problem with abuse, if there has been shown to be a problem, rather, to be abuse in the workspace. and or the dangerous nature of the job warrants it, the courts will actually waive that requirement and they will say, no, that's justified. Again, another balancing act done in each case. I will say that the courts in Western Canada tend to be a bit more likely to rule in favor of public safety in this regard, or employee safety, than err on the side of employee privacy, which tends to be done more often in Central and Eastern Canada. In Irving, for example, we've got a Supreme Court decision in 2013 which says that if there's reasonable cause, so let me go over the facts first. The craft paper mill in New Brunswick had no drug or alcohol policy for 15 years leading up to this case. And the employer decides to unilaterally impose this in the unionized context. Random drug tests are introduced, it's contested by the union, and it's held that if there is reasonable cause, management can, in fact, unilaterally impose this. In this case, there was no general problem that already existed in the workplace. Reasonable cause was not satisfied to have safety concerns trump the privacy and dignity of employees. And the safety relatedness of this job is not the only thing that matters, but only starts with proportionality exercise. That said, if the safety concerns are grave enough, or there's evidence of a possible problem, the courts will get away. That's happened here. We've got an oil field worker with major potential safety issues. As you can see, heavy equipment, high voltage, chemicals, radiation, high temperature steam, on and on and on. The court essentially held in this case that the potential issues were bad enough to warrant it in this case.
So the next topic on this with respect to cannabis in the workplace is whether or not your private employer's medical benefit plan will include coverage for medical cannabis under those plans. And really, looking at this, it depends on the wording of the plan. If the plan does not include language specifically identifying or covering medical marijuana, there's a good chance that you're not going to have it covered under the private employment plan, simply because medical marijuana does not have, medical cannabis does not have a drug identification number associated with it that will be obtained through the approval process of Health Canada. So it's not actually a drug, but there are exceptions to this, and it appears that there is a case in Nova Scotia at the level of the Nova Scotia Human Rights Commission, Skinner, whereby the Human Rights Commission in Nova Scotia determined that a private employment medical plan must cover the cost of medical cannabis because the drug medical benefit insurer could not show that there would be a financial burden in covering medical cannabis under that particular plan. So in the lack of that evidence, the Nova Scotia Human Rights Commission determined that it could be covered. There is no unreasonable basis to reject coverage of medical cannabis under that particular plan. But that's a unique decision to Nova Scotia. I would not take it as far as saying that that will be the case in all private medical plans, and it will again depend on the wording of the plan to see whether or not there would be any coverage available. I would not be surprised if we see insurers in this country modify perhaps the language of their policies to make it explicit that perhaps medical cannabis will not be covered. So we may see that as a developing trend in the future.
I have nothing to add, so if anybody has any questions, feel free.
Now's the time.
Gentleman in the second row.
Can you hear me?
I can.
What advice would you have for, say, professional certification bodies, say somebody like the Bar Association, putting requirements of intoxication to hold on to your certification?
So is the question, if sobriety or freedom from impairment of cannabis, if that is a requirement for certification to a professional body, is that possible?
Or can you lose certification? Or could you lose certification for being impaired?
You can step up with the microphone.
Yeah, perhaps it's helpful.
Yeah, loss of certification could be a consequence. If that were to be implemented by a certifying body, certainly these discriminatory provisions, the same actually analysis takes place as in the employment context. As human rights legislation applies to all private actors, including a private certifying body, or even a government certifying body. That exact same situation would apply. So, if you have a medical prescription, and they say you lose that as a result of that medical prescription, I would suggest you at least have an argument for discrimination, yes.
Thank you.
Welcome.
Hello.
Hi.
The question is regarding the DIN number.
Yes.
Is it possible that there is a drug identification number out there, but we haven't gotten our hands on it yet?
No, there isn't. There isn't a drug substance.
No, not to my knowledge. Yeah.
Not to your knowledge, so it's possible that there is one, but we haven't gotten our hands on it yet.
Well, it'd have to be issued by Health Canada, and I have no information that Health Canada has issued a drug identification number for cannabis.
Do you have any information stating that Health Canada did not issue a drug identification number?
I can't speculate on what it didn't do. All I know is that it has not produced a public DIN number for cannabis.
If you have information that there is a DIN out there, I wouldn't mind seeing it actually.
Sure you would.
Absolutely. You seem confident about that.
Well, you never know what's out there, right?
Yeah.
Fair enough.
If we don't have proof that it's not out there, then we don't have proof that
It's difficult to prove negative, so.
well, as long as somebody has a number out there somewhere, you might want to bring it to you for review.
Ultimately, in the context of a drug benefit plan, the number itself is not really relevant. It's the wording of a policy, and in the Nova Scotia case in particular, the wording of a policy encompassed medical marijuana. It was a covered drug or medication under that policy and was not excluded. So simply, the Human Rights Tribunal in that case, even without the DIN, whether it existed or not, was a bit irrelevant in that case. It was covered under the plan. The trustee under the plan refused to provide it, and that refusal was held to be discriminatory.
So even without a DIN number, it can be insured as a
Yes.
medication that would have a DIN number.
And in the past, on a case-by-case basis, insurers that have taken the position that it is not covered have on a case-by-case basis granted one-time exemptions for particularly charitable cases where people have very, very significant illnesses that are on a cocktail of 40 or more medications. None of this is working, but cannabis does help. They provide that, but it's a very rare thing. I can only think of two off the top of my head. Certainly not a general rule.
I would also imagine insurance isn't proactively trying to help the rest of the individuals that they possibly have their plans to do the same thing for these other specific individuals. They're probably not educating the public about what happened.
Right, and at the end of the day, I think this knows, if I was speaking 4 months ago, my answer would be very different. But with the outcome of that Nova Scotia appeal board, I think we're going to look at this issue. It will be live in the courts, and it will be in flux. My answer might change in another week's time based on what comes out.
In other words, stay tuned.
Stay tuned. Thank you very much.
Cheers.
Yes, hi, good morning. Thanks for an excellent presentation. One of your slides made mention, I know it's mostly about employment law, but you mentioned about landlord and tenants. Is there anything a tenant would need to do? Say the person is qualified under ACMPR to have medical cannabis. Is there anything a tenant needs to do in relation to their relationship with their landlord to go ahead with that?
This is a very live issue as well. It has actually been in the news. There was a story in CBC not too long ago about a firefighter who was kind of stuck with a tenant who was growing marijuana, medical marijuana, and lost their insurance over the property as a result of this. This is a oversight, in my view, of how the legislation exists as of right now. Ultimately, it is up to the landlord. I mean, a landlord cannot kick out a tenant for the use of medical marijuana because that's discriminatory, but they're kind of stuck because they need to find insurance that will cover growing marijuana in that circumstance. Perhaps the solution in that is to find, for example, under the MMAR's a designated person to grow for somebody in an area that, or from a licensed producer, for example. From an area that's not within that, from within the rented premises. That might be a solution that works out for everybody, and that would be ultimately where I would move with that. But as you're completely correct in that the law has not caught up to reality.
So there's no provision, as far as you know, in the ACMPR that addresses the question? Like, does the tenant need to get permission from the landlord, or does the landlord have permission to take extra steps to change things? Do you know about that?
To my knowledge, it's not addressed in that manner. Again, I think we're going to be seeing, because of this issue.
Okay.
Yeah.
My understanding as well is that landlords across the country are not wholly satisfied with the proposed draft bill, the Cannabis Act, because it is silent on this very point again. So it's in limbo, and it is no. So there is hope that would be clarified in improving that bill as law. That it becomes clear. Thank you.
Yeah. It's regarding what Mr. was talking about a little bit. Is there basically a difference in between growing tomatoes in my house and growing my medical cannabis in my house when it comes to the law?
Yes. That's the short answer, and the reason is, in that exact context, an insurance company can refuse to insure a space because of it's being used for growing even medical cannabis.
Okay.
I think there is room for an argument to be made, absolutely, even from a discriminatory point of view, that an insurance company is choosing not to insure because of ultimately what is medical cannabis reason, or a reason arising out of that medical cannabis use. I agree. Very likely, practically speaking, if I'm growing tomatoes as opposed to marijuana, no, there's not much of a difference, but legally, yes, there is. And it all depends on the wording of the insurance policy, unfortunately, and that's the contract by which you need to interpret. So if the parties have a contract which is held to be discriminatory, you can raise the argument that it's discriminatory, and the courts will correct it.
And I'm sure we will see an argument raised that the denial of coverage by an insurer to a landlord for the tenant's growing of medical cannabis plants is discriminatory. We can see that argument being raised, certainly, and it'll be interesting to see how the courts deal with it.
Okay, so if I understand correctly, it's illegal for me to grow tomatoes in my house?
No. That's not correct.
I would have to tell the landlord that I'm growing tomatoes in my house for it to be legal?
There's no.
Okay, so basically in the same context of medical cannabis, I don't have to tell the landlord that I grow cannabis medically in my house.
The landlord in these cases are basically specifically saying, are discovering after the fact, right? Whether that's by way of disclosure or ordinary inspection, 24 hours notice, whatever it is. Then they discover it. Now they discover that there's no insurance in place because they have to disclose that to their insurance company under their policy.
That I'm growing tomatoes?
No, I'm talking about marijuana.
Oh, why do they have to disclose that I'm growing medical cannabis to their insurances if I can grow tomatoes?
Simply because that's under the policy of insurance. That's the terms of the policy.
But to my knowledge, it's none of their business, and it doesn't have to do with the policy. It has to do with growing tomatoes or...
It affects insurability, the risk of the insured. It needs to know the risk involved in insuring the property. And that's a material risk that I would, if I were a landlord, disclose to my insurer on the risk that if I did not, that would affect coverage. And they're saying to me as a landlord, if I didn't disclose that there was a growing of medical cannabis in the unit, that's not a risk that they would accept. So I think it's reasonable to disclose that to the insurer.
Do you have to disclose that you're growing tomatoes in your home to the insurers for it to be insured?
Maybe we could have this discussion a little later.
Yeah,
after
perhaps
the,
it's,
from the rest of the presentation. We have another question as well. Thank you.
I wonder if one could make the argument that one absolutely needs medical cannabis in order to function, or focus, perhaps.
That'll be an interesting point. I haven't seen it raised in any case, but I'm sure that at some point soon, somebody will say, challenge, saying that I am required to use it. It's medically necessary to make me feel better at work and more productive, more energetic.
If I understand correctly, you're saying that the use of cannabis in this circumstance, far and away from creating an impairment, is the opposite effect. It's actually making me able to do my job in the first place.
And I work with I represent a whole community of people who live with PTSD, for instance, right? People that live with symptoms of nightmares, flashbacks, and intrusive thoughts. A lot of people that live with that diagnosis die by suicide. So in cases that I know of, cannabis has helped tremendously and has had a superior result as opposed to taking the pharmaceuticals like anti-anxiety, anti-depression.
You can actually see
like that. So I was wondering if it's possible to make the case.
Oh, absolutely. There's actually a lot of parallels in this with ordinary prescription medication. And the exact same analysis of the court will apply in all cases. They will look at it, and if an employer has terminated or disciplined an employee, the argument is, well, that's actually makes me better at my job. The court will look at that and say, well, that's unjustified.
But if you're going to make the argument, I would counsel that you get good medical evidence to support that argument. If you do not have a doctor who is willing to say that, good luck.
Well, I know a few.
Yeah, there are. I recognize
there
that.
There are a few. Right?
Yeah.
Anyway,
everything is based on evidence and a balance of what the court can find.
But I wonder how one would prove that.
You essentially need a doctor's doctor's opinion. Yeah.
Thank you very much.
So,
hi, there's a quick question. Thank you first of all for your presentation. It was very interesting. With respect to searches in the workplace, so I'm wondering, I don't know you covered, I don't think too much, but where we have the employer that sets some parameters around having searches of workers, whether it be pat-down type searches or the privacy of those. Can you make a few comments on what you think would be the legalities around that and how you might guide an employer to have a search policy in place?
As of right now, it's in a recreational context. I think they would be within their rights to prohibit that. because it's an illegal substance. And if you're on their property, they wouldn't want an illegal substance on their property. That may very well change post-legalization. It would be effectively similar to having a six-pack of beer in your locker at work or something to that effect. In that case, again, I suppose all of those considerations which I have mentioned previously would apply if it is against the employee code of conduct, for example, to have recreational cannabis post-legalization in the workplace. My simple recommendation would be not to do that. Whether, in fact, the employer can impose discipline will be a balancing match again. I would suggest, yes, they can impose at least discipline in that case. Maybe not outright dismissal, but again, that progressive and proportional set of discipline.
Okay, so the key would be to incorporate language into the code of conduct.
Yes.
That would enable the employer to take certain steps, and then to act within the law when if they find something that shouldn't be brought into the workplace, then to take reasonable steps to deal with the employee, whether it be discipline, etc., to kind of follow the code of conduct. Right?
Exactly, and our recommendations to employers in this situation is always, first of all, to anticipate the legalization. I guess step zero is to make sure you have a policy in place. But step one is to review that and make sure that it is up to date. Exactly, and anticipates legal recreational cannabis. And then beyond that, when there are issues in the workplace arising under that code of conduct, to document everything. And that goes for employees as well. Just document everything and make good notes, because if it goes to court, it's all based on evidence.
And assume, if you're an employer or an employee in this context, assume that it will go to court. Be prepared. Prepare your notes the best you can so that you have, and anticipate that a judge will be looking at this, because it is such a novel issue.
Thank you.
One last question.
Again.
Yeah. You had mentioned at the beginning that employees will have a duty to disclose taking medical marijuana. I'm also wondering, is there a duty on behalf of the employer to request medical information when impairment is suspected?
Now, if we're talking about the medical realm, absolutely. In the recreational realm, I would say yes. In the medical realm, I would also say yes, depending on the argument is stronger depending on the job for certain work. If you're in a safety-sensitive position, for example, I would say no question the employer has the ability to know what medication their workers are on, whether that's cannabis or any other prescription drug, doesn't matter. With respect to something where your work is not affected at all by your use of cannabis, or your form of cannabis is a non-intoxicating form, that's going to cause problems, and that will be a fight, absolutely. Again, it's not exactly clear what the law says right now. The easiest solution is one that everybody can agree to. But if an employee is not going to disclose something, you'd better make sure as that employee that you are in fact not impaired. Because if it goes to court and the court finds that you are even slightly impaired, and that has possible consequences, even to your ability to do your job, whether it's safety sensitive or not, it's not going to look good on you, right? So again, all I can say is it depends, right? But it's a very long answer. There's no easy answer. But there it is.
What I would counsel in that situation is for the employee to disclose that they do have prescription for medical cannabis, and to work with the employer to develop what's called an accommodation plan, and that is that there's an investigation undertaken by the employer to determine whether or not the use of medical cannabis is somehow going to impact that employee's job. And medical evidence will be requested of the employee by the employer to show what are the limitations in your work from the use of medical cannabis. And at that point, the employer can obtain its own independent medical examination of the employee to determine whether or not the medical evidence relied on by the employee in support of a prescription for medical cannabis is reasonable. So it could be, eventually, it could be a battle of the experts as to whether or not there's impairment or it has any impact at work medical cannabis does.
So, thank you.
Yeah.
Do you think maybe you could come and ask your question directly with them? Thank you very much. Thank you very much for your presentation, and we'll resume at 1:30 this afternoon.